You're watching India Ahead.
The Delhi High Court has rejected an application by a tenant that requested for the suspension of rent due to the COVID lockdown. The High Court order provided some relief to the tenant, however, and said that some postponement or relaxation in the schedule of payments can be provided to the tenants owing to the lockdown. The counsel of the tenant had sought waiver of rent or some partial relief on the ground that lockdown has caused serious damages to the business. The court has held that if the tenants continue to occupy the rented premises, they are bound to make payments for the same. To talk more on that, we have Pragya Bhushan, senior advocate, joining us on the broadcast here. We also have Chetan Sharma, India Ahead News editorial director. He continues to be with us on this broadcast. Pragya Bhushan, if I could come to you, it's a very important question, a very logical point. Businesses, of course, are not doing well, and tenants may ask for suspension or relaxation with regards to payments. But what do landlords do in such a case? In this particular case, we've seen the Delhi High Court has said that, one has to make the payment, one has to pay the rent. There might be some relaxation, maybe, there might be some postponement in the schedule of payment. But it is mandatory that you have to pay the rent if you continue to occupy the premises. But what do landlords do in such a case? How can these conflicts between the tenants and, landlords be avoided?
Right. In fact, in this particular case, even the Honorable High Court of Justice Pratibha has considered the fact, but there cannot be a strict guideline on this particular matter, because there would be thousands and thousands of cases from all over the country in regard to such kind of issues where the tenant is unable to pay the rent, and of course the landlord's living is dependent upon this particular rent only. So there is some broad guideline, of course, in such kind of cases which the Honorable Court has considered, that if there is no such clause of suspension of rent in any particular lease agreement or rent agreement, then of course suspension of rent cannot be considered just due to temporary non-user of the rented premises. We have to consider that they are still occupying the premises, and they are still intend to use the premises in future course of action. So they cannot suspend these rents, but of course it can be considered that they may delay paying the rent, or there can be change in schedule of payments, or there may be some kind of relaxation, maybe waiving a little amount of rent or those kind of relaxations. But of course this is a source of living also for the landlords. So there cannot be
Pragya, what does the law say about it? You've been saying there can be, yes, as the Delhi High Court pointed out today in its order, said that, there can be, some postponement of in the schedule of payment. But of course, the rent cannot be suspended. The payment cannot be suspended. But what does the law say about it? How long can that period be? Because there are cases in which, tenants continue to occupy the rented places. The court earlier, in the case of students and laborers, the MHA order that had come in, after which the Supreme Court had put a stay on that when it was being asked to revise. The MHA order said that, the students and laborers, of course, they cannot be evicted for a month at least for non-payment. But, there are a lot of people, including students, laborers, and, the other section of the society which are still not paying their rents.
Right, we'll have to consider, because this is a new kind of situation, not just in India but all over the world, and we have to consider the actual situation, and accordingly even the courts will decide how long we can relax the things. Otherwise, even the tenants will have to decide whether they are going to use the premises in future, or they are deciding to evict the premises if there is no work, especially in regard to commercial premises, because this particular case relates to Khan Market property, which is a high-end property, and the rent is too high. So we have to consider whether it is a residential property or a commercial property, whether the person who is occupying the property is using it or not, and then of course he has no source of income. That has to be considered. As per the law, there is no set guideline on the time period, because this is a new kind of situation even for us in judicial systems.
Yes.
But of course, court has considered
Yes.
Indian Contract Act Section 32, Section 56, whether force majeure can be invoked in such kind of cases or not. So, and of course, court has given a clear mindset that force majeure cannot be considered in such kind of cases. And because you are using the property, occupying the property, then rent has to be paid, though it may be delayed.
Chetan, what I want to ask you here is that, the question that would come to everybody's mind, it's a double whammy for the landlords here. Of course, on one hand, they cannot ask their tenants to leave the premises, and on the other hand, they cannot even force them to pay the rent. But these conflicts that are arising between the tenants and the landlords during this period, how can these be avoided? What's your take about that?
Well, the first thing, I think it's in the interest of both parties to try and find a middle ground, simply because from the landlord's point of view, even if he chooses to evict the tenant or non-payment, the chances of him getting another tenant so quickly is pretty next to nothing. So I think it is in his interest as well to ensure that a middle ground and a negotiable aspect is taken into account. And some kind of, at least obviously a discount or maybe a deferment is perhaps the best way out. But my question to Pragya is, Pragya, I understand the issue from the point of view of a residential place, right? Because that has been occupied and been used as well. But in the case of a commercial enterprise, you mentioned the word force majeure. In the force majeure, period, even if, for instance, that the area is occupied, but the area has not been used because business was shut. It's the same premise of the employees. The employees were not used because the business was shut. But the employees do not have the same ability as a claim as what the landlord has. So is that not discretionary and discriminatory as far as force majeure is concerned, particularly in a business enterprise?
Right, Chetan, of course, in case of employees, it depends what kind of employees are, what kind of company is there, who is the employer. Because on one side, we have unorganized business sectors, even those professionals like chartered accountants, lawyers and doctors who have shut down their offices completely, and their income is based on day-to-day basis. On one day when they receive some clients, when they get some clients, they are being paid by those clients, and of course in return they pay to their employees. When the offices are completely shut, when they don't have any income at all, so where are they going to give the salaries from? So that kind of hassles are of course will be taken up by the courts also, by the such kind of unorganized business sector also. And of course, it implies to the shops as well, the shop owners who have shut down their shops, they have no income at all. From where are they going to pay to their employees? So these kind of things will have to be faced by all of us, and we'll have to consider all such facts. Let's see.
That is what I'm saying, madam. Madam, that's exactly what I'm saying. So the same argument holds for that tenant, because he had no business, he has no way to pay, he has no way to pay the employees, which is fair. But he has no way to pay the rent as well. How can you enforce that? It's the same argument. That's what I'm saying.
In that case, of course, he can vacate the property if he doesn't intend to use it further after lockdown.
It's not about vacation.
He can of course come back to, because the premises will be vacant in any case.
It is not about vacation. It is about usage at a time of a pandemic and the application of force majeure. If it's being used against the employees,
I would like to tell you about this particular case. I would like to tell you about this particular case. This case had eviction proceedings from rent controller prior in 2017. And to stop those eviction proceedings, Honorable High Court had directed the tenant to pay a rent of 3.5 lakhs and still occupy the property, and he was not allowed to evict the property. So this is a totally different case. Of course, in this particular case also, Honorable High Court has said that we cannot have specific guidelines, although we can give a broad guideline.
Okay, let me ask you, Pragya. Let me ask you a simple question.
Yeah.
Are you a tenant?
No,
do you work out of a rented property?
No, I'm
my question: do you work out of a rented property?
No, I don't work out of rented property.
Well, then you're fortunate. Maybe you can have a lot of force. But trust me, I've spoken to a lot of people of your tribe, and they have been dead against this.
I would have to decide that
And they have raised their voice.
Because I'm unable to pay the rent.
All right, Chetan and Pragya, I won't have much time here. Thank you so much, meanwhile, for your inputs. And we do believe, these are unprecedented times. These are unusual times. Of course, there are no specific guidelines or no specific law, regarding this particular issue. But what's really required is that landlords and tenants in this case might, try to find a middle path. They might just try to reach to a mutual agreement in order to, find a solution to this problem. That's the only resort that looks like is feasible during these times. Meanwhile, thank you so much to my panelists here for joining us on this broadcast, sharing those valuable inputs with us. With that, it's time for a short break here. More on the other side.